If you have a revocable living trust, one of the things you want to ensure that you do is to make sure you add your future assets to it. I'm Darcel Lobo. I'm an estate planning attorney. I've been helping clients for about 16 years now throughout Washington state with their estate plans, with their wills, with their trusts, with trust administration, with probate. So let's talk about what happens after you create your trust. So once you have your trust created, it's been signed, you have funded it, you are all good to go, except that you have to make sure that you are continuing to add any future assets to that trust as well. And so let's talk about some of the two common assets that we usually deal with after a trust is formed. So usually it's going to be a bank account and real estate. So maybe after you form the trust, you open a new bank account, you open a new savings account, you open an investment account. Or maybe you bought a new house, you bought an investment property, you bought a second home. We want to ensure that if you want the trust to control that asset and control what happens to that asset after you've passed, we have to make sure the trust actually owns it. So let's start with bank accounts. For bank accounts, it's pretty easy. I think the easiest thing to do is to add the trust as a beneficiary to that bank account. So whether it's a checking account, a CD, a savings account, an investment account, adding the trust as a beneficiary, I say is easier because if you make the trust the owner of the account and you title that account in the name of the trust, you're going to find that you're going to need to get, maybe a new account number, maybe a new checks, maybe a new debit card issued. And that can just be kind of more work for my clients. Not that it's a bad idea or a wrong idea. I just find that for my clients, usually it's easier and simpler for them just to name the trust as the beneficiary. So entirely up to you, but you want to just ensure that if you have a new financial account of any sort that you create or that you open after you've created your trust, you want to make sure the trust controls it. If you want it to be distributed according to what the trust says. Now, maybe you have other beneficiaries on it and you don't want the trust to be named, that's fine. This is just for the accounts that you want the trust to control it. You want to make sure the trust is either a beneficiary of it or that the trust actually owns and is the title owner of that bank account. Now let's get into the next one that I usually deal with more, which is real estate. So again, you formed your trust, you have signed it, everything is good to go with the attorney, you have your trust, and then you buy another home. You buy, and this can be a condo, a single family house, a townhome, it could be vacant land, it could be a cabin, like whatever it is, you have bought some more real estate. If you want the trust to control that real estate and what happens to it, we have to get it into the trust. If you don't, this is where the pour over will comes into effect, that if the house is not otherwise provided for after you've passed, your pour over will catches it, and what it should say is everything that would go through probate should go to my trust. So the pour over will take that real estate and put it into your trust for you. However, and this is a big however, that it only does so through probate. And for most of my clients who have created their revocable living trust, one of the primary reasons for them to do so was to avoid probate. So we don't want to inadvertently create a probate for the second home that you bought because you didn't realize what you needed to do with it. So I'm going to tell you what you need to do with it. So if you buy additional real estate and you want it to be distributed according to your trust, whatever your trust says. If the trust says it goes to my children, it goes to my friend, it goes to these charities, whoever you want it to go to, you want to ensure that the trust owns that real estate. And you can do this in two different ways. If you haven't yet bought the real estate, or if you're in the process of closing on that real estate purchase, you can make your trust the purchaser of the property. So instead of buying in your own name as Jane Doe, you would buy it in the name of your trust, which probably is something along the lines of Jane Doe Revocable Living Trust, something along those lines. And so that is an option. Usually that's only an option if you are paying cash for this purchase. If you are financing this purchase and getting a mortgage loan to buy this new property, the lender is usually going to want you to buy it in your personal name because the loan is also going to be in your personal name, and those two have to match. That's been what I've seen with lenders and what they required. And so if that is the case, and the more common process for getting the home into your trust that I see and help clients with is to deed that property into your trust after you've closed. So you bought the home, you've gone through escrow, you've closed on it, the home is in your name, then that's when you would, call your estate planning attorney, call my office and say, hey, I just bought this property. I need to get it into my trust. And then we, or whoever your attorney is, can help you with deeding that property into the trust. One question that I see, and it's a good question, is that going to violate my mortgage loan? Is that going to violate the terms of the mortgage agreement that I have? Most mortgages do have clauses in them. I think every one that I have ever seen from a traditional lender has this language in it that prohibits you from transferring the property without their consent. However, what I will say as a caveat to that is that you are transferring it out of your name into your own trust name. It is still your property. You still have full and complete control over the property. And so I personally have never seen a lender create an issue from you transferring the property out of your name into your trust name, even though the property has a mortgage loan on it. If they had a big problem with it and were to make an issue of it, you certainly could undo it and just transfer it back into your personal name. But that would take it out of your trust. I've never seen that be an issue with a mortgage lender. Again, not to assure you or guarantee you that that wouldn't be an issue, but it's not one that I've seen in my over 16 years now of having helped clients with estate planning, real estate, all those things. So again, if it's going from your own name into your trust name, I've never seen an issue. You just keep paying the mortgage as you currently are. The mortgage would stay in your personal name. We're not changing the borrower on the mortgage loan. That would not be the trust. It's just title ownership to the property. We putting in the name of your trust. So if you need help with your revocable living trust, with your estate plan, if you've been wondering if a trust is right for you, you're not sure, but if getting your estate planning done has been on your to-do list, and you want to get it off of your to-do list, I'd be happy to see if my office can help you with your estate plan. You do need to be a resident of Washington State. I am only licensed to practice in Washington State. I would love to help you wherever you are, but if you're outside of Washington State, I would say check your local bar association at your state or county level to find an attorney in your area who's licensed in your area to be able to help you. But if you're in Washington and you want help with your estate plan, with a trust, with a will, I'd be happy to see if we can help you. I'll make sure I put our website right here for you, dowlawfirm.com. Also down below in the description, we'll have our contact information. So thank you. I hope this is helpful, and I'll see you in the next one.